The format will be as follows. Judges Salt and Judge Flores will each give a short presentation about their understanding of the rules and the salient points they believe that we need to know. Then they will each take turns answering questions that you have emailed in advance. And so we'll toggle back and forth between them. And then we'll take it from there. We hope to finish up by 5 o'clock. And I know they'll probably mention this too, but the Chief Judge Barbera's administrative order does answer a lot of questions. Now, we know it's, 27 pages long. You might not have taken time to read all 27 pages. But if you have a question, the answer is probably in there. But our judges are more than happy to try to answer them for you today. So without further ado, Judge Salt, we're going to go to you and have you kick us off. And I'm going to mute myself. A couple other housekeeping things before I turn it over to Judge Salt. We are recording this conversation. And Keith Chizik, we need you to stop presenting. There we go. All right. We are recording this conversation, so everybody knows. Hopefully it will be of some help for those who might not have been able to join us today. And our controller, Bill Haw, has the ability to mute everybody. Only you have the ability to unmute yourself. So if we see that some people have unmuted themselves, whether accidentally or otherwise, Bill will probably be muting you simply because it affects the sound quality of the presentation. And if there is an opportunity to speak and we're not sure that we're going to get to that, I already showed you how to unmute on the video. If you're on a phone call, the way you unmute is by using *6, and that both mutes you and unmutes you. So having said all of that, I now turn it over to Judge Salt.
And good afternoon, everyone. As we all know, this is something that none of us have ever experienced or ever wanted to experience, which is basically pretty much shutting down of the judicial system. And now we're in the process of trying to get things rolling again, understanding the health crisis that is going on. I think Judge Flores will agree that this reopening has a huge number of moving parts. It is dealing with staff. It is dealing with the health department. It's dealing with the backlog of cases. It's dealing with questions from litigants and from citizens about court processes and procedures. So we're kind of all in this together, and we're taking it one step at a time. I'm going to give you a perfect example about how things are going to be different, and we don't know when they're going to get back to what we call normal. Earlier today, I went with Judy Lohman, our court administrator, to check out courtroom 1 to see how many people could be allowed in the gallery of that courtroom with the social distancing guidelines. That courtroom, you know, is our largest courtroom. In the gallery, if we observe the requirements for social distancing in that huge courtroom, you can have 15 people in the gallery. That's it. And that is our largest courtroom. So, you know, the health department and all the other folks, we have to factor that into how many people we allow in the building, how we set hearings, and, you know, how many people we allow standing out in the hallways. All that is limited. So this great big building, that great big courtroom, you can put 15 people in there. It's just unbelievable, the limitations that we have space-wise. And that is part of the reason that Judge Barbera's order is so phased in, that while we're about to start phase 2, that basically the courthouse is still going to remain closed to the general public while we process where people can stand, where people can go to the bathroom, where witnesses can stay safely until they're called into the courtroom. And again, I think if you read through the administrative orders, that that concern, primarily for the safety of everyone that comes into this building, is a primary concern. The order does require people entering all the courthouse facilities to wear a mask, and that is to be enforced by local court security. We are planning on having screening questions. Right now, we are not planning on requiring everybody to have their temperature read before they enter the courthouse, but there will be screening questions. And I know one of the specific questions that I've been asked to answer later on talks about the details of how that's going to work. But I really just kind of wanted to put that point out to get everybody's attention. This is the kind of the limitations that we're talking about. Our biggest courtroom that usually can hold 100 and some people, we can put 15 people in the gallery in that courtroom. Again, that's one of the many logistical challenges that we have to getting everything up and running. And that's just kind of my opening thought for this town hall, just kind of get everybody's mind focused on that. Judge Flores.
All right, I unmuted my microphone. So I appreciate hearing from Judge Salt. I refer to her as my landlord, or more often my super. The county is our landlord here in the district court in Frederick County, so we have to follow whatever the county tells us to do. But Julie and I have both been over Chief Judge Barbera's admin order, and I strongly urge everyone to print out a copy if you're old school like I am, and look at the paperwork. Last night, Chief Judge Barbera issued an update, some corrections to what we're calling the big order, the reopening order. For example, in the original order, violations of probation were never mentioned in any of the district court sections. We just forgot to put it in. So there are always going to be changes, but the order gives a lot of guidance with what we're supposed to do. On Monday, phase 2 of the judiciary's plan kicks in, which doesn't mean a whole lot of difference for the types of cases that are coming in, but the order does give localities a lot of flexibility to add cases to the ones that are spelled out in the order. For example, in Frederick County District Court, we are going to be able to conclude our backlog of peace and protective orders, which is the top priority across the state for district courts in phase 2. We will complete those in the first week, next week, June 8th. That leaves us 5 more weeks to fit in other matters. So we have been trying to do that. I know I saw Mike Moore's name on here. It's very distracting. There's a little sign here, and it keeps blinking with the names of people that are joining. And I keep getting distracted by friends of mine, Larry Reagan, Laura Garcia from the PD's office. They just pop up. So I'm trying to focus here. Like Julie, we have same space concerns. Our district courtrooms, the 3 of them, about 10 people per courtroom is what we can get in there. But we appreciate you all participating in this. I personally thought we'd get about 6 to 8 people on this call, and we have well over 100. So little intimidated, wasn't quite prepared to give formal remarks to a lot of people, but I think I know just about everybody on this call. So that being said, we're going to try to address the questions that were sent to us ahead of time to give us something to throw out there for you all, and then we'll see how much more information we can get on there. Janice, with your permission, I'll go ahead and address the first question that was on the list that was assigned to me. Is that okay with you?
Go right ahead.
All right, so one of the questions that was submitted in advance was, will more hearings be telephonic regularly without request of counsel? We are setting some cases in, particularly some of these peace and protective orders, telephonically. Again, a lot of flexibility to the local jurisdictions. I know that, and Lynn Williams, hi Lynn, just chatted, can you include Washington County? And yes, I will. I have a specific question for Washington County. As most of you know, District 11 is Frederick and Washington County, so I will be addressing some issues to Washington County. There are some differences. that was one of the examples I was going to bring up. The Washington County Circuit Court administrative order from Judge Dwyer says no members of the public will be allowed in that courthouse in phase 2. And he certainly has the flexibility to do that. That's not how we're handling things here in Frederick County, the Frederick County Courthouse. We will have parties present, but certainly as you read the order, remote hearings are still allowed and permitted, and even in phase 5, which is full operations, you'll note that Chief Judge Barbera said even in phase 5, she would like, I don't have it as organized as I wanted, but remote operations may still continue. So this has been a big change, and it will continue to be part of our process for the future, I believe, to do quite a few things remotely. As of now, we're handling both types of cases here in the District Court for Frederick County and in the Washington County District Court. I know our judges in the Washington County District Court would prefer to have more cases in person than remote, but there are going to be times when somebody screens out. We're just not allowed into the courtroom because they can't answer the questions properly, and we'll deal with that. I've had people go to their car in the parking lot across the street and call in and participate remotely. So remote operation, there are all kinds of issues to deal with. We are doing the best we can, and we're trying to make it as easy for all you folks as possible. And Julie, I'll defer to you for the next question.
Okay, thank you, Dino. The second question was regarding the verbal health screening questions that will be presented to those seeking acceptance at the entry of the courthouse. What happens to the case if a party or an essential witness screens out on the protocol and cannot be admitted? That's part one of the question. What will happen then is we have a form that we will give to any litigant or party or attorney, quite frankly, as to this is the protocol to follow if you are not permitted into the courthouse. For counsel, it will be to call judges' chambers, and for any witness or any self-represented party, they will be given a single phone number to call in the assignment office to indicate that they are here for court. They were not permitted in because they did not pass the screening, and arrangements will be made either that day to have them participate on a remote basis, or if it's not capable to be done that day, the case would then be rescheduled quickly to get that case resolved with that person being able to participate remotely. So the sheriff's office is aware of this protocol, and we actually will have printed copies, and it's actually in, I think, yellow paper. So it's going to look different than other items that if they do not, are not allowed to come in, they're going to given a special piece of paper to call and to indicate that they were not permitted in, but to allow them to participate remotely. The second part of the question was, as a follow-up, how does the court ensure that parties aren't just basically making up their answers so they get a postponement? Well, quite frankly, there's no way to do that. If an individual says that they were in contact with someone that is symptomatic of COVID-19, we're going to err on the side of not permitting them into the courthouse, and hopefully we would be able to get them linked up with a remote proceeding so that we could still continue with the proceeding that was set that day.
Okay, thank you. Now, which one of you is taking the next questions?
Well, I've got a rather lengthy one that was specific to Washington County District Court, but it addresses a number of landlord-tenant type issues, and we are handling those pretty uniformly. So, first of all, in the amended order last night, there was some more information added in there about landlord-tenant breach of lease cases. In phase 2, starting on Monday, we are permitted to consider emergency breach of lease, and emergency wrongful detainer cases. And there's a definition of an emergency breach of lease. So we are starting to consider some of those. The paperwork related to those types of cases, breach of lease, failing to pay rent, and small claims cases for that matter, which is in this question, can still be filed. But as far as processing them for hearings, if it's not an emergency wrongful detainer or an emergency breach of lease, then it's not going to be addressed until at least phase 3. And I think failure to pay rent is phase 4, if I'm not mistaken. Again, I have it here kind of broken down for myself. Failing to pay rent is phase 4. So a lot of these issues can be addressed by looking at the order from the chief judge. There were some questions about drop boxes, and there has been a drop box at both Frederick County and Washington County, mainly for pro se folks to file paperwork, because as you know, all you attorneys are supposed to be filing in MDEC in both of our counties. Part of this question deals with specific questions about the Hagerstown Housing Authority and issues relating to pending evictions where there's a warrant of restitution. And again, in the amended order, warrants of restitution come July 25th, which would be the beginning of phase 3, those warrants can then be served. That is also in conjunction with the Federal CARES Act, where we're just not permitted to go forward on executing evictions per the CARES Act. The question goes on asking for more detail. I'm not reading it because it's very lengthy, but the CARES Act requires any landlord requesting a warrant of eviction, even if it's not going to be acted on, to affirmatively state that they're not subject to the prohibition of the CARES Act. If there's any type of federal funding or lending that was put on the property at any time, then you can't go forward with the action. So the district court has created a form. Now, everything that has, every failure to pay rent action that is filed right now has to have that CARES Act certification. We've created a form. There are forms for everything in the district court. It makes life easy that you have to fill out when you file this type of thing. Again, a lot of this is contained in yesterday's amended reopening order. So landlord tenant is an area where we have done very little, even though there are a lot of shortened time frames, and we're all very stressed out about dealing with that and the explosion of eviction notices that are going to go out once we hit phase 3. All of these folks, all of these landlords have filed these actions, and they've just been pending for months and months. But we are trying to address all of those issues related to landlord tenant. So that's just a little flavor of the issue we're dealing with, that section of what the district court handles. But again, no significant action on a lot of the landlord tenant cases till at least phase 3, and failing to pay rent phase 4. Julie, I'll turn it over for you.
Okay, thank you, Dino. The next question that I had was about if a hearing was scheduled in the coming weeks before the pandemic hit, are those hearings occurring as scheduled, or are they being pushed back and or reevaluated for the necessity of being held in person? I will tell you that judges, magistrates, and the assignment office have been working on the docket almost every day and every hour as this whole pandemic has developed, and as this new, we finally got the reopening plan there. And we're trying to reset every single case that was set before and during the period of time where there was a shutdown. We are also trying and working on what we're calling triaging the cases, particularly, quite frankly, the criminal cases for individuals that are incarcerated that will not be able to have a trial by jury at least until October. we're working on trying to identify those cases and to have status conferences on those cases to try to get those moving through the system. Because, of course, jury trials are not scheduled to resume until October. And that's just going to create a huge backup in the system. Like Judge Flores was just talking about the huge volume of landlord-tenant cases. We're going to have a huge volume of criminal and civil jury trials that have been on hold for 6 months. So we're working on triaging the cases. We're working on alternate ways to get cases resolved. I know that Judge Sandy and Magistrate Raymond and Magistrate Minner have been working hard on the family law docket. Judge Adams, Magistrate Raymond, and Judge Martz Fisher have been working on the Senate docket, the delinquency dockets. I've been working on with the assignment office and the state's attorney's office and the Office of the Public Defender on how we're going to get the criminal cases rolling again. I know that Mike Moore has contacted me about when they get resolutions on JTP cases about setting up a disposition day docket to try to get those cases moving. So, it's kind of twofold. We're trying to clear out the backlog and try to, get the hallways or decks open so that when jury trials resume in October, that we can take care of those cases. I will tell you, I know that, like I said, the assignment office has reset things several times because we weren't in the process. The first order was going to end April 5th, and then it was going to end another day. So they've been resetting stuff all along. And some things have been reset several times, and we're aware that it's very confusing for everyone, but we're working really, really, really hard to make sure we can get all of those cases appropriately triaged and assigned.
Judges, I have a follow-up question on that, which I hope you'll excuse me for not putting it in chat, but I talk much quicker than I type. How quickly, if you can even answer this, do you think you will be able to catch up with that backlog? Is the goal to get it caught up by the October start of jury trials?
That would be wonderful. It's not going to happen. I mean, you're talking about, we were, prior to the pandemic, we were setting merits domestic cases in 21 in March and April of 2021 anyway. We've now taken 6 months basically of contested cases and put that on top of what we have already scheduled out through March of next year. It's not going to be resolved by October, unfortunately. I mean, that's just the realistic answer. We still only have 6 judges and 2 magistrates and only so many courtrooms. That's why I say we're really going to be working on really encouraging alternative resolutions to cases so that we really do only have the cases that absolutely cannot be resolved any other way than by court time. But like I said, you just basically take 6 months of cases, because we're not hearing any contested, say, domestic merits cases until after July and or August, depending on how complicated they are. And putting that on top of what we've already scheduled, which we were already scheduling out through, again, March and April of 2021. And that's not counting we're going to be taking a judge away or a judge or 2 away to be dealing with the jury trials that have been backed up with people that are incarcerated that are going to have priority on the docket. So that's just not going to happen, unfortunately.
Okay. Judge Flores, do you have the next question?
All right. So the next question I have is, Has WebEx been considered as a platform for continuing court use? I've heard success in use of that platform. So let me stop that question right there. I've never heard of WebEx. I don't know what it is. We can tell you folks that very early on in this process, Zoom was approved and then it was disapproved by the courts. Apparently, there were some security issues. Everybody acknowledges that. Zoom has made some changes, and my understanding is that the federal government is using Zoom. So our security folks, the acronym is DUIT, do it. I can't remember what it stands for. They're analyzing that to make sure the court would be satisfied with the security of Zoom. The thought process is that we will be able to go back and use Zoom, which I understand is a very easy platform to use. Skype for Business is all we're using right now, and I know we're all having issues with that, but the court is looking at the technology, and security has to be a very important prong for us to consider. Is technology available for use in court proceedings in which the parties may need to present audio video in the courtroom when the court is doing teleconferencing? Meaning, is the court using the TV at all times during the teleconference? Is another TV available? That's an excellent question. Courtroom 1 in district court, my courtroom, I do have the display system where you can plug a laptop or a cell phone into the system and it appears on the TV screen in the courtroom that we use for bonds, at the screens at counsel tables, and at the one on my desk. It's been pretty successful, although having the adapters, if you have a Mac computer, don't bring it to District Courtroom 1. We don't have the adapter to plug it into the system. I think all you folks know that we're trying to get lawyers in contested matters, which we're not hearing right now, but when we do, to file all of your exhibits electronically before court. So we don't have to be passing papers back and forth, which is another risky type of behavior. And we're trying to come up with a way where pro se's can do that as well. In district court, in most cases, we're not really concerned about creating a record because with de novo appeals, we always turn the exhibits back to the party or the attorneys in any event. So we're trying to come up with a way where even pro se's can download evidence they would like to use in their hearing that the other side would have a chance to see before court, and then we can show it on the screens in courtroom 1. My courtroom is the only one that we have that in at this moment. I'm sure Judge Solt has the ability to deal with technology in the courtroom as well, but I would remind everybody we're trying to get attorneys to file exhibits that they intend to present in court on MDEC prior to the hearing, so we can avoid marking paper and passing it around. It's one of those things, that's the way we always did it, and it's just not the way we're going to keep doing it right now. There was one other part of that question. Will attorneys be permitted to come into the courtroom as has been done pre-phase 2? And again, I think I kind of addressed that. The answer is yes. We're not going to deny someone access who wants to be in court in person. We're also not going to force anyone, at least through phase 4, to come into court if they really don't wish to do that. We will do our best to accommodate everyone, whether they wish to appear in person or remotely, and we'll do the best we can with the technology we have. Julie, go ahead.
I was just going to say, we do have one smart courtroom, courtroom 5, does have multiple screens and the ability for people to plug in their laptops, etc. That right now is the only courtroom that has that already set up. I know that the Judicial Information Systems, JIS is the shorthand term that we use, is working on improving the technological capabilities of the courtrooms. But we also have the problem that this is an old building with old wiring, and it's not always that easy to put that additional technology in place in the courtrooms, particularly the older courtrooms in the original section, courtrooms 1, 2, and 3. But we are working with JIS and working with the local tech people to get as much appropriate equipment in place. And like Judge Flores said, you know, with MDEC, there's no reason that exhibits and things like that can't be filed electronically ahead of time, because literally the issue of handing an exhibit to counsel and then handing it to a witness and then handing it to a clerk is not something that's going to be happening anytime in the near future. The only other thing I want to say about the technology is one other thing that the courts are concerned about, as well as the security aspect, is if it is a hearing that is required to be on the record, whatever platform is used has to be compatible with the CourtSmart system so that someone can access the record, at least in circuit court. Right now, Skype for Business is easily converted to the CourtSmart system. So when we have a hearing that is recorded with Skype for Business, it can be recreated as part of a record for purposes of appeal. And again, that's another factor that we have to take into consideration before accepting another platform. I will say, and I know some of the domestic lawyers already know this, that we've been utilizing teleconferencing and phone hearings for uncontested domestic matters. And that has been working very, very well. And it's, of course, a heck of a lot easier than trying to work through the Skype for Business or any other platform having the video capability. And I know that that has been working very well. That is very likely to continue well into phase 3 and 4 of the reopening.
Okay, thank you, Judge Salt. I show another question for you, Judge Salt, but I believe you probably combined it with a very similar one. So we have some chat questions, but before I go to some chat questions, did you indeed address all the pre-sent questions that we have, or is there another one you would like to address?
Again, I think I accidentally skipped over the question about what are the likelihood that family law hearings set as scheduling conferences will not be rescheduled. We are planning to reschedule everything. If for some reason your case is not rescheduled, contact the assignment office to file a line with the court. We are not intending on having hearings disappear. And again, just because of the massive numbers, if for some reason we miss one, please file a line with the court, call the assignment office. We absolutely plan on rescheduling everything that needs to be set and heard. Okay,
very well. All right, and judges, I'd like to turn to the chat questions and I will read them out loud. But before I do that, I just want to give you an opportunity if there was anything else you wanted to say before. Oh, looks like we're good. Okay, so it looks like we got a few good questions here in chat. The first one is, has there been any discussion about bringing back examiners to handle uncontested divorce hearings to free up the magistrate's dockets?
That is a question that is best left to the administrative office of the courts. Right now, the administrative office of the courts and Chief Judge Barbera do not want examiners hearing cases when we have magistrates available to do it. So they have not considered that. It has been mentioned to them. And right now that is not an approved way to go.
Okay, thank you. Next question is asking about state policy that jail inmates jury trials go first. I guess, in other words, is there going to be such a policy? It's kind of 3 questions in one. I'll read all 3 and you can address it as you would like. Current juries set October to December are pushed back, ? State versus local policy, ? I guess it's some general information is being asked about jail inmate jury trials and how that will be handled.
We would like, of course, to focus on the incarcerated individuals whose cases are over what would have been the Hicks deadline, who have been incarcerated the longest, for those cases to have priority. However, it's going to depend on counsel and their ability to be prepared in the process. As we know, a number of these cases, especially the most serious ones, are represented by a small number of practitioners who you have to give counsel time to be prepared from one case to another, and they can't do multiple trials with multi-witnesses, multi-day trials back to back. So, you know, obviously we're going to try to focus on those to try to get those cases for the people that have been incarcerated the longest, to get those cases resolved first, depending on counsel's availability and the ability to be prepared to present folks. Because you also have to remember that anyone that is incarcerated, they've only had limited access to their counsel during this time, because the detention center has not been allowing counsel to visit, because they've been afraid and working very hard to try to keep the virus out of the detention centers. So you have to factor all that in. But are we going to try to get those cases done first for people that have been incarcerated during this time? Absolutely, to the best of our ability.
Okay, so classic lawyer answer, and it makes perfect sense. It depends. But totally
it does. You know, that's the reality.
Right. Okay, next question, and this could, I think, be addressed by either of you. Query the problem of remote witnesses being coached from off camera.
The idea of handling contested matters where you have witnesses testifying from another location is very problematic. Most of the things we've been handling have not been contested. I have had a number of contested matters with witnesses present in the courtroom. I've had very few where there was a contested matter with someone off stage, and it's a little problematic for me. Again, we're allowed to have people in the courthouse here in Frederick County and in Washington County District Court. My personal opinion, I would prefer to have any type of contested matter with testimony on the record with the witnesses in the courtroom. It may not be possible if someone screens out of the questions out front. We're going to do everything we can to address any issue that counsel brings up to us, such as we're concerned that somebody's holding up cue cards in the background for a remote witness. But obviously, there's only so much control we have over everything. We will do the best we can to make sure everyone gets a fair and appropriate day in the courtroom.
Okay, thank you. Next question. How long should we wait before filing a line or making an inquiry about a hearing that has not been rescheduled yet? And in particular, the questioner was asking about domestic hearings, but civil cases too. Point being, we don't want to pester the clerks with questions and interfere with getting things rescheduled. But we also don't want to make sure that they were forgotten.
I would say if you have not gotten a rescheduled notice within the next 2 weeks, that I would feel free to contact to file a line. I know that our assignment office has been bringing people in, stuffing envelopes, sending stuff out. So even though they may not have yet gotten a notice, it may very well have been rescheduled. But I would say if you haven't heard anything in 2 weeks, please feel free to file an appropriate line with the court, and we will see where it stands.
All right.
Court civil matters, phase 4 is when we're going to start handling civil matters. So we're probably not even going to be touching scheduling those until we get into phase 3 and have a good handle on that, which is exactly what we're working on right now, since we're starting phase 2 on Monday.
So circuit court, wait 2 weeks, district court, wait longer for civil matters. Okay, very good, thank you. I was wondering that myself. Next question, are there any coordinated efforts with the state's attorney's office to resolve en masse district court cases, such as a plea docket, a time-served docket, etc.?
I'll address that as far as the district court is concerned. We've been doing that in both counties, Frederick and Washington County. on a daily basis. And I think in both counties, the state and the PD have been working together to try to identify cases that should come before the court to try to resolve them. We got rid of a lot of folks that were incarcerated, many high-risk folks incarcerated, making them the top priority to try to resolve their cases. Now that we're moving into phase 2, we're certainly going to be adding in guilty pleas, cases that are resolved with the state and the public defender. Here in Frederick, I mentioned earlier, we're going to spend the first week of phase 2 resolving all of our peace and protective orders. That gives us 5 weeks to bring in other cases. Washington County, they're going to spend the first 3 weeks of phase 2 handling nothing but peace and protective orders, knowing that there are bonds, other emergency matters can be set in. But yes, other guilty pleas, other resolutions can be set in and taken care of during phase 2, and we certainly intend to do that.
Okay. I accidentally skipped a question. It's related, but I don't know that you specifically addressed it. If we have plea agreements worked out with the state, how do we get on the docket? Is it different from Washington County District Court?
I've been seeing in Frederick County, the parties filing a joint motion to set in for a plea hearing, and we set it in almost immediately so that we can get it taken care of. Sometimes it's completely agreed upon, the sentence. Other times the state may be asking for one thing, the defense will ask for another, but we're getting it set in for a hearing. I just ruled on one today, and I emailed the attorneys directly to say, I'm sorry, we can't set it for tomorrow, but we just don't have time for tomorrow. By the way, just to remind everybody, the Frederick County Courthouse is closing at noon tomorrow. It's being shut down because of protests that are supposed to start at 2 o'clock. So the sheriff asked for the safety of everyone in the courthouse to close down the courthouse. So district court bonds are at 10, circuit court bonds at 11, courthouse shut down at noon. You can still file things electronically, but there will not be folks at the courthouse to process them. So bottom line was, in that case, I apologize to the attorneys. We set the case that they filed for a guilty plea today for Monday. In both counties, we're still trying to resolve those cases, and we will get them in.
Okay, thank you. Next question. Will out-of-state travel prohibit access to the courthouse in the screening process?
I don't think that is one of the required questions. So unless we get a different recommendation from CDC or the health department, no, that would not be. The questions that have been approved all deal with contact with COVID or any of the symptoms of COVID, but do not talk about out-of-state travel.
Okay, good to know. And that is all I have in the chat box. I do have one additional question, and then not seeing any others, I think I'll leave it to the judges to wrap up. My question was sparked by your comment, Judge Salt, about using different methods to resolve cases. And of course, mediation occurs, I'm thinking, in the district court on the spot. I have to confess, I did not read all 27 pages of the Chief Judge's order yet. I have to assume that mediation is going to be, at least mediation at the courthouse itself, is going to be out of the picture for a good time to come, especially given that those witness rooms are so small. Is that the case?
The circuit court mediation is going virtual. If it hasn't been published yet, starting Monday, there is going to be virtual mediation with remote access to the mediators. Our family services and ADR reached out to the local mediators to see who was interested and who would participate with remote mediations. We got a wonderful response from the local mediators, and that program will be up and running starting on Monday. And also family services will be starting to offer remote services, I believe, beginning Monday as well. So even though we're not allowing people in the building, we are still having the availability of those services, although again, on a remote basis.
Okay, thank you. Judge Flores, can you add to that?
No, I have nothing in particular to add to that. I think we're in good shape.
Okay. But I assume district court mediation program will not be happening for a good bit of time to come.
Right. I mean, we don't have a place to put people right now, and given the screening, that's not even something we've discussed about bringing back at this point. Again, no civil cases are coming back to court before phase 4, so haven't even discussed it yet.
Got it. Okay. We do have one additional question that's come in. I might need a little help from Mr. Finnegan here. He writes, multiple civil circuit court cases all rescheduled on July 16. Will every contested circuit court case be rescheduled? Do we need to get a little more info there, or can we answer that?
Janice, scroll down on your chat.
Ah, ta-da. I thought I was at the end. Okay, oh, there we go, sorry. So, follow up, sorry, question was whether every contested circuit court case presently scheduled before August 31 is going to be rescheduled. Sorry about that, Larry. So was every contested circuit court case presently scheduled before August 31, is it going to be rescheduled?
For certain, every contested circuit court family case before the July 20th, I think the Monday is the 23rd, will be rescheduled. What's going to be set, what's going to be able to be heard between that July date and August 31st is something we're looking at right now. But there's nothing, if you look at the administrative order, we're not doing contested hearings in family cases until after June 20th. So if there are a bunch of cases set the 16th of June, they're not going to, July, they're not going to go. They're going to get rescheduled.
Okay, thank you. One more question has come in related to screening again. If on the morning of a multi-day trial, the attorney, client, or key witness has a fever or COVID-like symptoms, aside from contacting the judge's chambers and alerting the other side, is it safe to assume that the trial will be postponed? And I'm thinking in particular, what if it's not a key witness, but that witness needs to go on or should be going on that day? But the question was posed as attorney, client, or key witness.
Well, obviously, if the attorney or the party is unavailable, then it's very likely the case would be postponed. If it's a witness, it's a multi-day hearing. It's really that, I hate to say, but another attorney answered, it all depends. If it's a witness that could be rescheduled for later on, or if it's a witness that there could be a stipulation to the testimony, or the testimony could be taken by telephone deposition and admitted that way. I mean, there are a number of different possible resolutions to that question. We also, if I could just kind of summarize what we've been talking about here with all the magistrates and the judges, is we have to start thinking of doing things in a different, more efficient way. The old way that everybody kind of did everything, and we scheduled everything and we had hearings, it's got to change based on the backlog of cases to get things resolved. So people, the old expression, think outside the box about what you can do to make your case go forward when it's scheduled. The only other thing I want to add is, and I think Judge Flores will agree with me, if we get a call from counsel that they have gotten a resolution on a case, we are going to make every effort to get that case in and heard and resolved. So if you have an agreement in a criminal case, in a domestic case, or whatever you need to do, please notify us, because we want to get those cases in, get them resolved, and get that case over if we can. So please, if you've settled the case, call us. We're going to do everything we can to make sure that that goes through.
Okay, good advice. And I have two more questions. They're trickling in, but they're both related to jury trials. I'll just ask them both at once. One is if Zoom jury trials are being considered as an option in Maryland, and the other pertains to how jury selection is going to work when the trials begin again.
What I can tell you is there is a special committee of judges that are working on a proposed plan for the resumption of jury trials that are going to deal with all of those issues. That group will be reporting to the Conference of Circuit Court Judges and to Chief Judge Barbera with her recommendations sometime in mid-August. So all things are being considered at this point, and I just can't say right now what they're going to be recommending. But yes, everyone is very concerned about jury selection, about where we put prospective jurors, about if there's still a requirement for social distancing, what courtrooms can we use, what jury deliberation rooms can we use. All of that is still up in the air. And it's, again, one of the many things that we're working on and we need to consider as we reopen.
Okay. And okay, here are our latecomers. We got a flurry, like 5 new questions in here. It is the top of the hour. Judges, I will give you the option if you need to be somewhere, or do you have time for a few more? They're all like valid questions here. Let me know.
Now please, let's go on for a little while longer.
Okay, we got it. Okay, so first, do we need to request new scheduling orders for cases that have been postponed, or will those automatically be issued when the cases are postponed?
If it changes the deadlines for discovery, which of course it will, because counsel hasn't been able to talk to witnesses or to get the discovery, if you get new trial dates, it will very likely have new scheduling orders.
Okay, and if it doesn't and you feel you need one, simply, I would imagine, ask for it.
Absolutely.
And next question, I just received trial notices for 12 breach of lease cases on the same day, same time, with multiple plaintiffs' witnesses. Not sure how that can possibly work.
And I see Lynn's question. So clearly that's out of the Washington County District Court. And I don't think I have enough information to really give Lynn a great answer to that. Certainly call the clerk's office tomorrow, because they're closed now, and find out specifically what's going on with those cases. The date itself is important because we've already talked about landlord tenant. The breach of lease cases, if they're emergencies, then they are going to be set in quickly. If they're not emergencies, then they aren't going to be scheduled until later on in phase 3. So Lynn, I think the best solution I can give you is call the clerk's office tomorrow and try to find out what's going on with your specific cases.
Okay, and Judge Flores, looks like a follow-up for you. Does that mean no PHs or anything criminal other than bonds in district in Washington County? And
I see that Lauren Villa's question, and I think Lauren's asking, as in phase 2, is that what we're going to do? Well, the order says preliminary hearings. Let me find the actual language. Preliminary hearings with a proposed resolution. So they are going to be setting preliminary hearings in Washington County. Again, after they get through the 3 weeks of peace and protective orders, that's the top of the priority list. But they are going to be setting them in Washington County with an eye towards cases that are going to be washed down to district court, that informations will be filed in the circuit court, and attorneys should be reaching out to the state to try to resolve those cases. Frederick, they've been doing that here, and of course in Frederick they use the grand jury frequently, and the idea is that in the very near future, meaning this month, the grand jury in Frederick County will start meeting, and then indictments will be issued, and those will take care of the preliminary. But we are, as I mentioned earlier, we're trying to find a way to get as many cases resolved in the 6-week period that we have until phase 3, and we can add in any type of case if we feel it's appropriate. So certainly other criminal matters that do not require testimony or are contested. That's pretty clear from the order. We're going to squeeze in both counties to try to get them done and get them out of the system. Thanks, Lauren.
Okay, wonderful. I think that is actually it. I thank you both, Judges Salt and Judge Flores, for doing this town hall with us. And I think we got a lot of questions answered. I'm sure there will be a lot more in the days and weeks to come. Other than referring to the order, did the judges have any advice on kind of the pecking order of where to start first, second, and third to get your questions answered?
I mean, speaking for me, obviously our clerk's office is terrific to deal with in both counties. You folks know that just by calling our clerk's office, someone's going to try to help you and answer your questions. I have no problem. Anybody wants to shoot me an email if they have a specific question about general practices. Obviously, I can't comment on specific individual cases, but we're certainly going to try to help and get people taken care of. And I'm sure Julie will probably say pretty much the same thing. Julie, anything to add on that?
Just going to say, you know, we're all in this together, and we're all figuring out how to do it, because none of us have done this before. So, you know, we're here to try to help you. And like I said, we're a team. We can't do this without each other's cooperation. So please feel free to contact us. And we will also be giving you more information and more direction as we get it from leadership. So thank you, everybody, for your obvious interest and attention and assistance through this process.
Well, thank the two of you very much. You're receiving some nice things in our chat boxes, and hopefully we never have to do this again either. Hopefully a few good things will come from it as well. So everybody have a great day and a good weekend, and thank you for tuning in.